Insert case from release item 41, second appeal 116 of 2025.
This is a defendant first party second appeal against the judgment of affirmance. The plaintiff filed title suit for declaration of right title interest over the suit property, a decree for recovery of vacant possession of the suit land, and to grant permanent injunction lawsuit. Mechanism prior to the judgment passed by the trial court lawsuit, facts of the plaintiff case lawsuit. Paragraph.
You are the plaintiff?
I am the defendant first party. The plaintiff filed title suit for declaration of the right title interest. Suit was decreed against which lawsuit the defendant lawsuit filed first appeal, which was also dismissed, against which lawsuit this second appeal has been filed before this honorable court lawsuit. Para two lawsuit. The
Correct was the trial court judgment.
lawsuit. May I
Page number.
page number lawsuit 40, page number running page number 48. Para two lawsuit.
Yes.
The plaintiff case as per the plaint dated 16/8/1999 is that land of plot number 1/2 of Moja Pakur number so and so Pakur now Pakur town. This big plot is comprised with total area about more than 48 bighas. The one Amiya Kumar Pandey of Pakur Raj Estate was the owner of the 6 kathas land of the aforesaid plot number so and so. That the said Amiya Kumar Pandey sold his aforesaid 6 katha land in said plot number so and so to the plaintiff number 1, 2, 3 and 5, and 1 katha 10 group each on 22/19 through for duly executed registered sale deed being sale deed number so and so sub registry office. All the aforesaid purchasers were delivered the possession of their respective purchased land on the same day by the said seller Amiya Kumar Pandey. Later on, that is on 10/8/1988, the plaintiff number 2 and 4 also purchased jointly 2 kathas 10 group and just contiguous south to the land covered by the aforesaid sale deed number so and so out of said plot number so and so from the defendant second party through a duly executed and registered deed of sale being sale deed number so and so of Pakur sub registry office on the same day, and they were delivered possession of the same by the said seller. The plaintiff after purchasing land covered by the aforesaid 5 sale deed made pakka boundary wall jointly from all the direction over the major portion of the same, and they also made construction of a big gate in the northern boundary of the same for existing interest, and they kept some portion of same covered by the sale deed number 9 and 8 vacant for the purpose of parking of their vehicle on the same. Where the said vacant portion covered by the sale deed number 998, which is not fully described in the schedule appended at the foot of the plaint, and for the sake of the brevity and convenience, the same will be termed as a suit land hereinafter in this plaint. That on 26/4/1919, the defendant first party started making erection of the boundary wall over the suit property in order to possess the plaintiff from the same possibly only the plaintiff number 1 reported the matter to the Pakur town police, who then visited the spot and stopped the construction work of the defendant first party over the suit line and submitted report before the learned SDM Pakur for initiation of proceeding under section 107 and 144 CRPC against the plaintiff number 1 and 2 and defendant first party. That on the same day, that is on 24/6/1919, during the inquiry by the Pakur town police, the defendant for the first time claimed the suit land on the basis of the sale deed allegedly to have been executed by the defendant's second party on 1988, being the sale deed number shown Pakur registry office in his favor. The plaintiff stated that the defendant's second party neither any minor in his right title interest or possession over the suit land or had any authority to sell the same to the defendant first party. The further Samyukta from the perusal of the boundary mentioned in the aforesaid sale deed number so and so, it would be evident that no land was available for the sale on the northern boundary of the aforesaid 6 Kathar land of the Amya Kumar Pandey to the defendant first party on 19/3/1988 as alleged by him that the sale deed number 19/3/1998 is illegal and fictitious, on which does not confer any right to the defendant first party over the suit land, but the defendant first party has claimed the suit land on the basis of illegal and fictitious sale deed, and on 19/8/1999, the plaintiff and their entire family members had gone to the Devghar for Puja. They returned Pakur from there on 24/8/1999, and taking advantage of their long absence from the Pakur, the defendant first party had made construction of Pakka boundary wall and a small wall over the suit land. Thus, he dispossessed the plaintiff illegally from the same, and hence necessity of the suit for declaration of right title interest of the plaintiff over the same and for recovery of vacant possession of same by the demolishing the boundary wall and wall from same through the process of the court. The plaintiff had got their subsisting right title interest in the suit land had been in continuous possession of the same since the date of purchase till 18/8/1999. And old boundary wall constructed them over the suit land is still existing. Neither the defendant first party nor the defendant second party have had any minor of their right title and interest in the suit land, nor any of them possess the same at any time prior to 19/8/1999. The claim over the suit land by the defendant first party on the basis of alleged by him are false, illegal, fictitious, not illegal, that the defendant first party has made preparation for construction of the suit land. The plaintiff are also entitled to injunction restraining the defendant first party from making any sort of further construction. They are on failing it. The plaintiff will be put to the relative loss, trouble, and harassment notwithstanding they have got a good prima facie title over the suit land. That with a view to avoid the technicality of difficulty in feature in the suit. The defendant second party has been implicated in the suit. The defendant first party has claimed the suit, including 3 feet rasta on eastern boundary on the basis of alleged sale deed number dated 19/3/1993 allegedly to have been executed with the defendant second party. The cause of action of the suit is on 26/4/1999 on the date when the defendant first party claimed the suit land on the basis of alleged deed of sale dated 19/3/1988 and 98/91. The
What were the issues framed?
is para 6 laws. Para 6 laws. The issue number 4 laws is
The contesting party was defendant first party.
first party laws. Laws is the issue number 4 laws is this is very much important laws. Have the plaintiff very right title interest over the suit land laws. And now laws is we can see.
Issue 5 also.
Laws
2, 4 and 5.
4 is the most important laws.
What about 2?
I am also coming 1 and 2 laws. 1 and 2 also.
It was held to be barred by limitation or not?
No, it has not held the bar by limitation laws. Para 14 laws issue finding the issue number 1, 2 and 3.
If it has not been held by barred by
Barred by
limitation, so we need not
Yes.
venture into that.
Yes.
What about 4 and 5?
Issue number 4 and 5. Laws in mechanics, I pray laws in mechanics issue number 4 laws. This is very much important laws. Issue number 4 laws. Whether the plaintiff have very right title interest with respect to suit property laws.
Page number?
Page number laws. Internal page 36 laws and running page 83.
Yes.
Yes. The burden proving issue number 4 is on the plaintiff have alleged in their claim. The plaintiff examined 9 PW including the plaintiff number 1 in support of
What is the finding?
findings laws mechanics laws page 37 laws. This is important. Page 37. Internal page 37, running page 84. The plaintiff went to Devghar for offering a puja on 19/8/1998 and returned on 24/8/1999. Then found that plaintiff first party has constructed the boundary wall of the suit land, also dug a small well in it. The instead affidavit prepared on his saying that he has put his signature on it. In cross examination, PW and the important. The cross examination PW has deposed that he has seen the Khatian and related document regarding the disputed plot. That he does not know as to in whose name and deed the recorded. The plot was Rani Jyotir Muig, the Bola Babu, Anu Babu, and Omia Babu, Tara Babu, and grandson of Rani, but he does not know as to how they were so related. The Bola Babu, also known as Uma Prasad Pandey, he is the dependent second party. They have purchased from the Uma Prasad Pandey a lot of land in disputed plot number so and they have also purchased land previously from him. That his father also purchased the land towards south of the disputed land after purchasing. The defendant number has purchased land from Uma Prasad Pandey. They have also bonded the purchased land except the 1.5 kattha land of front side window. They have not stolen more than purchased land of 8.5 kattha land, but they have also measured the land at that time. That he knew the defendant number one father who purchased the land from Rani Jyotirmui in disputed plot and constructed house whose gate is towards east side and there is also a gate towards west side. For exit the disputed land and just after exit of western gate of the house. There is well in the disputed land and there is a constructed generator room by the defendant in the disputed land. There is a road going to Rani Jyotirmai Stadium just adjacent to north of the generator room and adjacent to road towards the north. There is a two-story house. This is important. The Omya Kumar Pandey alias Kanu Babu has 6 kattha of land in plot number 122. That he has seen the deed of 6 kattha of land of the Omya Kumar Pandey, but it was not the deed, but some other paper on the stamp paper, and it was unregistered. He cannot tell its year and date. Omya Pandey lordship the claiming the land on the basis of unregistered deed lordship.
Was it exhibited? Not exhibited.
Not exhibited, and the plaintiff purchased the land Omya Pandey. The person who filed the title should has to prove its own state lordship, but it is an unregistered document lordship. आगे पढ़ रहे हैं, but he could not take possession thereof. बोला possession भी नहीं है. Could not take possession thereof. He has not demanded the same before instituting the suit. That he has not late measuring the land. He cannot tell us how long and wide is land of the 8.5 kattha land. Towards the 8.5 kattha lands, there is a private rasta of Uma Prasad and the 2.5 kattha land from the Uma Prasad Pandey in south of the 6 kattha. He wrote an application to Daroga, the instituted 144 lordship. Lordship, the plaintiff purchased the land Omya Pandey lordship, who has no right title interest with respect to suit property lordship, and the defendant purchased the land Uma Pandey lordship. He is the relative of the Raja lordship. And the plaintiff also purchased some part of land from the Uma Pandey defendant second party lordship by virtue of registered sale deed lordship. Meaning they are admitting that Uma Pandey is the owner of the suit property lordship. Para 37 लिखते हैं that the contentious defendant has not proved facts related to his defense. Para 37 notes. The plaintiff has to prove its own title lordship.
The court held that plaintiff has proved the title.
Yes, which is absolutely wrong. The DT.11.11.11.2025 himself admitted that the Omya Pandey has no right title interest. He is not the owner of the land.
Omya Pandey is the vendor of plaintiff.
Yes, vendor of the plaintiff.
ओमिया पांडे
एमिया, कहीं जगह ओमिया कहीं एमिया लिखा हुआ है, कहीं ए से लिखा हुआ कहीं ओ से AMIY, फर्स्ट में एमिया लिखा हुआ है, लास्ट में ओमिया लिखा हुआ
अमिया पांडे
है जी। और हम परचेज किए उमा पांडे से, डिफेंडेड सेकंड पार्टी लॉर्डशिप। अब प्लेंटी भी कुछ लैंड उमा पांडे से परचेज किए, बेभर्ती और रजिस्टर्ड सेल भी, सेम प्लॉट ऑफ लैंड। अगर ये लैंड उमिया पांडे का था तो फिर क्यों प्लेंटी परचेज की? और अपीलेट कोर्ट जो है सिर्फ डिफेंडेंट का एविडेंस डिस्कस किए, प्लेंटी का कहीं भी डिफेंस को एविडेंस को डिस्कस नहीं किया।
what is the registered deed exhibit number of plaintiff?
प्लेंटी एग्जिबिट नंबर पेज 63 और पेज 63
Plaintiff का exhibit number क्या है?
एग्जिबिट नंबर 1 सैलरी चार एग्जिबिट है, एग्जिबिट 1, एग्जिबिट 1 बाय ए, एग्जिबिट 1 बाय बी, एग्जिबिट 1 बाय 2, पेज 63। और एग्जिबिट 4 भी एक बार देख लीजिए नीचे, उसी प्लॉट को डिफेंडेंट सेकंड पार्टी से परचेज भी कर रहे हैं, जो हु इज द रियल ओनर ऑफ सूट लैंड लॉट से खुद परचेज की है। एग्जिबिट 4 लॉट से 10/8/1988 को एग्जीक्यूटेड बाय उमा पांडे इन फेवर ऑफ द पवन कुमार भगत इन जगदीश ही इज द प्लेंटिफ बिफोर दिस ऑनरेबल कोर्ट लॉ।
In spite of this, why did the court decide it against you?
The court held that the defendant has failed to prove his title loss. Page 37, para 37 loss.
Para 30.
37
30.
30.
Para 28.
20. Okay. Thus, the plaintiff proved the facts relating to their case, while the constitution even has not proved the facts relating to its defense lordship. It is absolutely perverse lordship. The PW9 himself stated that the Omia Pandey lordship sold the land, there is no right title interest lordship. तो सादा एग्रीमेंट का आधार पर हमको प्लेंटिफ को बेच दिए हैं, उसको इग्नोर किए हैं लर्नेड ट्रायल कोर्ट, एज वेल एज लर्नेड फर्स्ट अपीलेट कोर्ट लॉर्डशिप। तो प्लेंटिफ का केस का
This particular document on the basis of which the plaintiff is claiming the title is a registered document.
Yes, registered document.
Plaintiff
Registered document. But defendant also purchased land from the Uma Pandey lords by virtue of registered sale deed.
Which document are you saying is Saga sale?
Which was not exhibited. The PW9 says that it is a Sada sale deed. Uma Pandey lords, page 37 में kindly से 1 second lords, page 37 lords, internal page 37. Now please say the Umya Kumar Pandey would Kanu Babu has 6 katha of land, plot number 122, that he has seen the deed of 6 katha land of Umya Kumar Pandey. It was not the deed, but some other paper on the stamp paper, and it was unregistered.
What is the date of this document? Maybe not exhibited, but something must have been stated about this document.
नहीं लिखा हुआ, he cannot tell its year and date.
Plaintiff number 1 was claiming the property on the basis of exhibit 1.
Yes,
Correct?
yes,
So exhibit 1 is a registered document.
registered document.
Then how do you relate this unregistered document to this exhibit 1?
The PW9 himself stated that
PW9, what is the sequence? Omia Pandey is the owner of the property.
not owner of the property. He is not the owner of the property. May kindly see pleading lordship.
Who was the owner of the property according to you?
Owner of the property is and the Raja lordship.
Raja.
Yes.
Okay.
And the Raja lordship executed in favor of the Uma Pandey lordship.
Will.
And the plaintiff also
Will
purchased
in favor of
Uma defendant second party. Uma Kumar Pandey.
Defendant second party.
Lots.
Probated.
No, not, it has not been mentioned whether it will have been probated or not.
But it was for the defendant to say probated or not.
Yes.
Registered or सादा भी.
ये भी नहीं लिखा हुआ हमारे written statement
Not probated. Right?
Yes.
Correct?
Yes.
And this is with respect to defendant second party.
Yes.
How is defendant second party related to defendant first party?
The defendant first party also purchased the land from the defendant second party by
So-
virtue of registered sale deed.
Just a moment. But defendant second party is claiming the property by virtue of an unregistered will. So, what is the right?
But the plaintiff, for that lordship, the case of the defendant plaintiff has to prove its own case.
That's right. But so far as
But-
defendant is concerned, defendant cannot claim title over it.
I'm not. Look, I purchased the
Are you
land.
claiming property by title or you are not claiming
You
title?
see, I purchased the land by virtue of registered sale deed.
That's right. From a person on the basis of
And the plaintiff did not challenge my sale deed
on the
also.
basis of it, on the basis of a bill.
But
Your vendor claimed the title on the basis of a bill.
bill,
Correct?
yes,
What about the plaintiff?
the plaintiff purchased the land Omia Pandey lots.
Purchased from
Omia Kumar Pandey.
OMIA.
हाँ कहीं ए लिखा हुआ कहीं ओ लिखा हुआ अमिया ही होगा ए एम
Fine. Okay. How did Amia get the property?
on the basis of unregistered paper lots.
Unregistered deed executed by whom? उसका उनका क्या केस था
वो
बताइए?
नहीं लिखा
वो
हुआ
कहीं नहीं लिखा हुआ।
नहीं कोई लिखा बट PW9 खुद बोल रहे हैं कि हम देखे हैं कि सादा पेपर
PW9 कौन?
PW9 लोग
प्लेंटिफ है खुद।
प्लेंटिव नहीं
प्लेंटिफ एग्जामिन हुआ है?
हाँ प्लेंटिव एग्जामिन हुआ
ये प्लेंटिफ का वेंडर कौन है?
प्लेंटिव में
अमिया पांडे।
पांडे
ओमिया पांडे।
ओमिया पांडे
डीड में नहीं लिखा है ओमिया पांडे कैसे? How is ओमिया पांडे related to राजा?
he is not related to Raja Lords.
आपका तो कोई राइट नहीं बनता है।
I am not claiming the right title interest lordship. The right title interest lordship has been claimed by the plaintiff lordship. For a full of the plain lordship, the plaintiff admitted the title of the Uma Pandey, defendant said, may I give lordship?
Plaintiff number 1 purchased the property by exhibit 1.
Yes.
Right? Exhibit 1. Who is the vendor of exhibit 1? Amya Kumar.
Both sale deeds were executed in favor of the plaintiff's lordship. Plaintiff number 1, 2, 3 lordship.
Where is the list of exhibits?
List of exhibits first. Page 63 lordship. Page 63.
defendant themselves are saying that the plaintiff has purchased the property from Amya Kumar Pandey. This goes to show that he has knowledge about the sale deed dated 19/3/88 executed in favor of the defendant by the same defendant.
But the plaintiff has to prove its own case. He cannot take advantage of the weakness of the defendant's lordship. He has to prove.
Did you, in your written statement,
Yes.
did you say that the sale deed on the basis of which the plaintiff is claiming the property, the vendor did not have the title?
Once a law mechanism para 3 and 4 of the plaintiff lordship.
Will you tell us from the judgment also it must be applicant? Was that your case that the vendor of the plaintiff did not have the title of the property?
Yes, para 8 law of the written statement also. Para 8 law. The plaintiff is
Para 8 is
para 8 of
regarding
the written statement. Just give me the Anya Pandey is not the owner of the land. Let me answer. Now let's make an easy appellate court judgment also. Page 19 lords. Point for determination. Whether the respondents plaintiff have right title interest over the suit land lords. That is, in this case, the plaintiff side claim that land of lot number so and so, model so and so, comprise the total area of 48 bigger acres. The Amya Kumar Pandey of Pakur Raj State was the owner of the 6 cut of the land of the approximate plot number so and so. That state Amya Kumar Pandey sold the approximate 6 cut land in the plot number so and so to the plaintiff number 1, 2, 3, and 5. 1 cut 10 to each. 22 1988 through the registered sale deed number so and so so and so. Purchaser of purchased land will deliver the possession of their respective purchased land on the same day by Amya Kumar Pandey. That on 10/8/1988, the plaintiff number 2 and 4 purchased jointly 2 cut 10 dhur land just continuous south to land covered by the appropriate sale deed number 22/98 out of state plot number from the defendant second party. If the Amya Pandey is the owner of the land, what was the occasion to purchase the same plot of land from the defendant second party lordship? The defendant second party to the registered state number so on the same day. They were delivered the possession of the same by defendant second party. The plaintiff after purchasing and covered by the appropriate 5 sale deeds made pakka boundary one jointly from all the direction over the major portion of the same. They also made construction of the big gate over the northern boundary of the same for exist and interest. They kept some portion of the same covered by the sale deed number so and so vacant from the purpose of parking their vacuum from the same. The said vacant portion covered by the sale deed number so and so described in the schedule of the plate is the suit. The suit land again sold on the basis of sale deed allegedly have been executed by the defendant second party on 19/3/1998, being sale deed number so and so. The plaintiff asserted that plaintiff second party had neither any minor right title interest or possession over the suit land, nor he had any authority to sell to the defendant first party. If the lordship, the defendant second party has no right title interest, why the plaintiff lordship purchase the land from the defendant second party, that is the Uma Pandey lordship? The plaintiff asserted that from the perimeter of the boundary mentioned in the aforesaid sale deed number so and so, it would be evident that no land was available for sale on northern boundary of the aforesaid 6 katha of the land, the Omya Kumar Pandey to the defendant first party. The defendant first party claimed that if the plaintiff had got a wrong boundary described in the sale deed number so and so by including the land of Sri Uma Prasad Pandey, which was subsequently transferred to defendant number first party on 1988, the plaintiff cannot take any advantage of wrong boundary described in the sale deed executed by Sri Omya Kumar Pandey, not by the Uma Prasad Pandey. Thus, the crux of the dispute is boundary of the suit and whether it is
After the selling of the 4 deeds by Amya Pandey, nothing was left to be sold by Uma Pandey.
There is a land lottery. It is a absolutely perfect lottery. The Amya Pandey was the owner of the land. The Uma Pandey land. Why I am saying lottery? Mechanic para 4 of the plant lottery. The plaintiff himself stated that he purchased the land Amya Pandey in same plot of land. If the Amya
He
Pandey
purchased prior to you, na?
yes.
He purchased prior to you.
But the Amya Pandey was not the owner of the land lottery.
But your vendor is also not the owner of the land.
I am not claiming the land lottery. The land suit filed by the plaintiff. He has to prove that. He has proved its own case. He cannot take advantage of the case of the defendant lottery. And the learned first appellate court, without discussing the plaintiff oral and documentary evidence lottery, only discuss the defendant's case lottery. On the basis of, I would like to discuss the oral evidence with regard to the defendant first party. Where is the judgment of the first relating to defendant's plaintiff's case lordship? सिर्फ डिफेंडेंस केस को डिलीट किया और उसको रिफॉर्म कर दिए. कोई भी पीडब्ल्यू का एविडेंस को डिस्कस ही नहीं किया है.
क्या सब्सटेंशियल क्वेश्चन ऑफ लॉ बनाए?
रोमन 2 लॉस. And 5 rules.
Exhibit 8 है.
हमारा केस सेंडरी डिपेंडेंट फर्स्ट पार्टी के नोट्स. डिपेंडेंट नंबर 1 का सेंडरी है 1998. हम परचेज किए हैं, उमा पांडे से लोग परचेज किए हैं 10/8/1988. फर्स्ट अपीलेट कोर्ट जो है आउट ऑफ 41-31 का भी कंप्लायंस नहीं की. Points has been formulated but did not discuss the evidence of the PW courts.
Heard the learned counsel pleading on behalf of Dr. The learned counsel for Tapilant has submitted that plaintiff had purchased the property by Exhibit 1 from Amiya Kumar Pandey, AMIYA Kumar Pandey, and the defendant Amiya Kumar Pandey, who had no right title with respect to the suit property. And the defendant number 2 has purchased the property by the Exhibit A.
Defendant number 1.
So defendant number 1 purchased the property by the Exhibit
Defendant
A.
first party.
Defendant first party had purchased the property by the Exhibit A. Executed by Uma Pandey.
Uma Prasad Pandey, that is defendant
Uma
second
Prasad
party.
Pandey, that is defendant second party, by Exhibit A.
Yes.
The learned counsel submits that the plaintiff failed to prove his case on the basis of Exhibit 1 as Amiya Pandey was not the owner of the property. He has also submitted that the vendor of the defendant second party claimed that a bill was executed by the Raja in favor of Uma Pandey,
Yes.
who sold the property to the defendant first party.
राजा का नाम है ज्योति मुई, रानी ज्योतिर्मुई.
The name of the Raja was Rani Jyotirmoi.
मुई.
Moi,
M-O-Y.
M-O-Y. The learned counsel submits that it was for the plaintiff to prove his case, and any deficiency in the case of the defendant will not entitle the plaintiff for a decree. He submits that this aspect of the matter has not been considered by both the courts,
Both the courts.
and therefore a substantial question of law being framed and decided. He has in particular referred to substantial question of law number 5 and
2 laws. Roman.
2 and 5. खाली टू ही तो होगा.
एक नोटिस की दूसरी परमिट मिली पेज 37 ऑफ द डब्ल्यू टाइप ऑफ
Two should be sufficient.
PW9 जो बोल रहे हैं ये it was not the deed but some other paper on the stamp paper it was unregistered.
2 and Roman 9 कितने? 2 and
रोमन 9 में तो गेट के
Roman
बारे
9 में से
में गेट के बारे में इसमें कर सकते हैं ड्यू टू ignoring the admission made on the PW9 relating to title of the Omia Pandey. The judgment and degree passed whether both the courts can sustain it.
इतना 1 2 से कवर हो
ठीक
जाएगा.
ठीक
Only 2 से कवर हो
जी
जाएगा. 2 खरीद ठीक है. After hearing the counsel for the applicant, this appeal is admitted for hearing on the following substantial question of law. Roman 2. Let notice be issued to the respondents for which requisites and recusals be filed within 1 week. Call for the records from the concerned court. Based on pre-property.
now so we can say IE number 10803 of 2025 date of delivery of petition has been issued also it is a residential house where I am praying for a stay in execution case laws.
I number 10803 of 25, this petition has been filed for stay of the execution case.
जी
Number 11 of 2017, said to be pending before the court of learned civil judge with back a senior division back to 1 part 2. The learned counsel for the applicant has submitted that a deed for delivery of possession has been issued by the court.
order of appeal line
So date करीब 15 December. Issue notice on the interlocutory application also till 15th of December. Further proceedings in execution case number 11 of 2017 is due. आगे disposal नहीं है, ठीक है? Records for
Violation item 31, first bill 154 of 2025.
if you want 4 of 25. Sorry?
Item 31, एक इसके बाद
Admit. Issue notice to the respondents for which requisites and recusals be filed within 1 week. Call for the records from the concerned court. Office to tracks be posted in post this case on 8 December. Waiting for this. कहाँ है इसकी अपीलेंट? कहाँ?
On hearing under order 41/11, item 32, second appeal 1510 of 2016.
Appellate court has been found. And on the last occasion, my lord has heard this matter, and here also this matter is heard. My lord, there are certain documents like for the main report and some zamindari receipts which were filed in the trial court but could not be marked as an exhibit. And my lord, at the appellate stage, my lord, when we filed application for marking those documents as an exhibit, my lord, the appellate court, your lordship, in the morning session, your lordship rejected, and my lord, in the later session, my lord, passed the judgment. My submission, your lordship, was that it has caused serious prejudice to us, as because, my lord, I had no opportunity to appear before the Supreme Court. This is
That
not-
order has to be challenged along with the appeal.
I have framed that point here. But my lord, I was examining the law on this aspect. Order 41/27 you must be added. Not Order 41 Rule 27 contemplates production of additional evidence to the appellant. The parties to an appeal shall not be entitled to produce additional evidence, whether oral or documentary in the appellate court. But if court from whose degree the appeal is referred refuse to admit the evidence sought to have been admitted, or the parties seeking to produce additional evidence establishes that notwithstanding the exercise of legal since evidence was not within his knowledge or could not, after the exercise of due diligence, be produced by him at the time when the degree of due diligence was not, or the appellate court requires any document to be produced or any witness to be examined to enable it to produce judgment or for any other substantial cause. The appellate court may allow such evidence or document to be produced or witness to be examined. So, but I want to argue, there are three limbs of the order for legal evidence. First link you will assume that court from whose degree the appeal is referred and refused to admit which ought to have been admitted. My case will assume is that these documents were already on record. So, my case is covered under section 47, order 41 rule 27A. So far as the judgments passed by Honorable Apex Court in the case of Union of India versus Ibrahim and several other cases, Honorable Court has said that it has to be considered at the time of the hearing. Additional evidence to be considered at the time of the hearing. But your Lordship, I have examined the law and there are judgments to that effect also. I came across a judgment passed by the Honorable Division Bench of the Bombay High Court, headed by Honorable Justice B.R. Gavai. And that judgment, your Lordship, clearly distinguishes that the lips, so far as the A and double A is concerned, it can be heard earlier also. It can be heard earlier. So far as the order 47 rule 21 is concerned, when a court requires an appeal, admittedly, the first appeal has to be heard. But my case, so far as my case is concerned, there was no occasion for the appellate court to dismiss it, and at the time of the filing of the case. which
Mr.
is
Secretary,
in fact
if the court allows your additional evidence, then the procedure has to be followed under Rule 28. But if the court is dismissing it, then under such circumstances, no further procedure
no,
is
but
required.
my dear, if suppose some document is essential, if some document as per the plaintiff is required, and I will show you from judgment, they have said that those documents were not filed, and the court has taken adverse influence. But what I want to say,
Not filed means somebody has to
not
exhibit the document.
not exhibit.
Somebody, some witness would have to come
The
and he will have to mention about that document. You
the-
see, you file n number of documents, but you do not exhibit it before the court. It is not taken on record.
Yes, I agree to that.
Then,
But your Rashid may highly appreciate. There
then
is a
how such a document can be taken into record without oral evidence?
But those oral evidences has also been made, but for inadvertence or your Rashid, whatever may say, but because of that he could not be formally marked as an exhibit. But basically it is a case under 47, Rule 41, Rule 27A. A says that the court from whose degree they have been required has refused
There is
to
no
admit or
refusal.
Well,
There is no refusal. There is no refusal. Rather, your witness never exhibited that document.
which ought to have been admitted. The
That's
one
right.
ought to have been.
Automatic admission थोड़ी होता है.
Not-
The witness has to draw the attention of the court with
I
respect to a
give
particular document.
attention before the appellate.
Which evidence?
Not,
Which was the document and which was the evidence?
Yes. Lashmi may kindly see my supplement here. Supplement
We are
here.
on the framing of substantial question of
Yes.
law. So that is not the question now.
Yes, that point I have taken.
And that additional evidence has been rejected.
Yes. That point I have.
What was the document you wanted to exhibit?
Well, the two documents we wanted. One was the further mean report, and another was the Jamindari receipt. We have brought out record in Hukum.
What is the date of this further mean report?
Further mean
Date.
report. Further mean report is on record.
Dated. And Jamindari receipt, how many? And what are the date? सर इतना टाइम नहीं है आप बताएंगे
तो डेट उसी समय का है एग्जैक्टली एग्जैक्ट डेट तो मैं नहीं बता पा रहा हूँ लेकिन फर्दर में रिपोर्ट भी उसी समय का जिस वक्त हमको गुमनामा 1941 का है और जमींदारी रिसीट उसके बाद
और आपको कौन से विटनेस से बोला है जमींदारी रिसीट के बारे में
हाँ
विच विटनेसेस से
दोनों को पहले हम ट्रायल कोर्ट दिखाते हैं kindly see internal page 70, running page 58 of memo. Tripod element applied. In the last portion, my lord will find that the Purnama is year 1945, admittedly Exhibit 7 is a non-registered document. No Jamindari received not any sheet of paper in respect of payment of rent to the ex-landlord at the time of surveillance and plan therefore prior to receive the release. Those documents are on record. They have simply filed an application that it may be taken on record, they will be marked with it. The Russian में kindly similar in appellate कर दिया.
आप उनको किसके एविडेंस में ये दोनों के बारे में बात आई?
ये खुद ये प्लेंटिफ के एविडेंस. वो अपना पिटीशन पढ़ो. सप्लीमेंट्री एफिडेविट के मार्फत से हम लाए बेसिक संपर्क है. उपरोक्त मुकदमे में अभिलाषी बालकेश्वर बैंक के द्वारा पूर्व जमींदार राजा रामगढ़ के अमीन के द्वारा निर्गत रिपोर्ट मुकदमा वाली जमीन बाबत रिपोर्ट अमीन फर्द रिपोर्ट मूल वाद में 2297 में दाखिल किया गया. यह मूल फर्द अमीन रिपोर्ट को अभिलाषी बालकेश्वर बैंक
एक सेकंड भूतपूर्व जमींदार राजा रामगढ़ के अमीन के द्वारा निर्गत
के बाबत फर्द अमीन रिपोर्ट नीम न्यायालय में मूल वाद
उपरोक्त मुकदमा वाली जमीन के बाबत फर्द अमीन रिपोर्ट
नीम न्यायालय में मूल वाद 2297 में दाखिल किया गया.
दिस इज इशूड बाय द अमीन
issued by the ex-landlord. अमीन रिपोर्ट पहले होता था उसके बाद
आगे
उसके बाद आगे पढ़ते.
यह कि मूल फर्द अमीन रिपोर्ट को
यह मूल फर्द अमीन रिपोर्ट अभिलाषी बालकेश्वर बैंक के द्वारा वादी गवाही के रूप में फर्द अमीन रिपोर्ट का अभिरक्षा दिनांक 14/2/2002 को किया, परंतु मूल फर्द अमीन रिपोर्ट को प्रदत्त अंकित कर जाना आवश्यक है. अतः उपरोक्त वाद अपील में फर्द अमीन रिपोर्ट न्यायिक हेतु अंकित किया जाना आवश्यक है. यह कि अभिलाषी की ओर से फर्द रिपोर्ट को सिद्ध करने हेतु अपराध साक्ष्य की आवश्यकता नहीं है. यह भूलवश निम्न न्यायालय के फर्द अमीन रिपोर्ट प्रदत्त अंकित नहीं किया जा सका. यह अभिलाषी जानबूझकर मुकदमा को विलंब करने के उद्देश्य से दाखिल नहीं कर रहे हैं. अभिलाषी को प्रदत्त करने हेतु आवेदन में विलंब हुए उसे माफ करने की कृपा की जाए. यह अमीन फर्द रिपोर्ट को अधिकृत साक्ष्य के रूप में अंकित करने की कृपा की. यह एप्लीकेशन था. यह एप्लीकेशन 14/6/2016 का है. और दूसरा एप्लीकेशन एक और 4/6 का था, दूसरा 14/6 का पारा पेज 10 में हम पढ़ रहे हैं. यह उपरोक्त मुकदमा में अभिलाषी बालकेश्वर बैंक के द्वारा भूतपूर्व जमींदार के द्वारा जमींदारी रसीद 22225 निर्गत जगतपाल वैद्य के नाम से किया गया था. जमींदारी रसीद को उपरोक्त मुकदमा वाला जमीन के बाबत निम्न न्यायालय में मूल वाद में 2297 की दाखिल किया. यह मूल फर्द अमीन रिपोर्ट को बालकेश्वर बैंक द्वारा वादी के रूप में जमींदारी का अभिरक्षा में दिनांक 14/2 को निश्चित किया गया था, परंतु मूल जमींदारी रसीद को प्रदत्त अंकित किया जाना आवश्यक है. उपरोक्त स्वस्थ बाद में फर्द अमीन रिपोर्ट को न्यायिक निर्णय हेतु प्रदत्त अंकित किया जाना आवश्यक है. जमींदारी सिद्ध करने की अपराधी आवश्यकता नहीं है. सिद्ध करने हेतु विलंब करने में माफी है. हमने यह एप्लीकेशन दिया और ये डॉक्यूमेंट भी रिकॉर्ड किया. एग्जीक्यूटेड नहीं है, दैट है.
और एप्लीकेट कोर्ट ने इसको रिजेक्ट कर दिया.
एप्लीकेट कोर्ट ने
क्या बोलकर
इसको रिजेक्ट कर दिया.
क्या बोलकर
सेम
क्या बोलकर रिजेक्ट कर दिया? What is the reason for rejection? Where is the order?
Last paragraph. Para 16 में page 16 supplementary affidavit.
Heard
From
from.
the result of record, it is clear that the appellants have filed a process petition by way of filing an application under Order 41 for the first time in this. The appellant has stated in the application that DT.11.11.2025 has proved custody of all the documents, but for the reason of evidence, Bhaskeshwar by result that his intent has not proved the custody, while these documents could not be executed. There is no explanation either in the application or during the course of hearing as to why the official documents were not exhibited by the appellants before the trial. In this regard, it is certain now the party can be allowed to filing cannot be allowed to filing the lacuna of his case in the court of appeal by rendering any additional document.
कस्टडी में आपका एविडेंस में कोई कस्टडी नहीं है, ये आपके नाम से इशू हुआ था, किसके नाम से इशू हुआ था?
ये मेरे फादर के नाम से। ये जो जमींदारी रसीद है और ये जो अपनी रिपोर्ट है या हुक्मनामा है, it is in the name of Jagatpal Vaid.
Who is the father of Balkeshwar?
The father of Balkeshwar.
Balkeshwar Singh.
Balkeshwar Vaid.
तो सिंह लिखा है।
That would have family.
और ये जमींदारी रिसीट किसको इशू हुआ था? जगतपाल को।
सूट बैंक का एरिया 322 जो है सो 94 प्लॉट के लिए है, 94 के लिए है और 1 एकड़ 12।
कौन सी सब्सटेंशियल क्वेश्चन ऑफ लॉ बना है? ए ऐसे नंबर अगर ए अलाउ होता है तो it will go back to the court.
Yes, that will go back.
Or we'll ask them to take it as additional evidence and then.
हालांकि पार्टी ने अपील इस केस में इसी पॉइंट पर जुडिशियस कोर्ट ने नोटिस किया था, उसके बाद ये लोग देर के थे मेमो हो गया लास्ट प्रोपोजल भी इस पॉइंट
तो बिना सब्सटेंशियल क्वेश्चन ऑफ लॉ फ्रेम किए,
दैट इज मस्ट
बिना सब्सटेंशियल क्वेश्चन ऑफ लॉ फ्रेम किए नोटिस किया था उनको।
उन्होंने बिना उसमें ऑर्डर देखा।
Then under such circumstances, if this has to be taken into consideration as additional evidence, and if no oral evidence is required for this, then second appellate court में तो ये काम थोड़ी ना होगा, ये काम तो वही करो।
फर्स्ट appellate court ही ये पहले डॉक्यूमेंट एग्जिबिट होगा, उसके बाद ही इसको सुनवाई,
उसके बाद इसका इम्पैक्ट लेके सुनवाई।
इम्पैक्ट
लेकिन ये ओरल एविडेंस से नहीं होगा, ये खाली ऐसे डॉक्यूमेंट्री एविडेंस लगाने से नहीं होगा, इसके साथ ओरल एविडेंस जरूरी है, क्रॉस एग्जामिनेशन जरूरी है। सब सादा डॉक्यूमेंट आप लगा रहे हैं, आप बोल रहे हैं खाली डॉक्यूमेंट एग्जिबिट हो जाएगा, इनको रिबटल भी मिलेगा, क्रॉस एग्जामिनेशन भी मिलेगा, ऐसे कैसे होगा? राइट, कस्टडी एक्सेट्रा हैज टू बी प्रूव्ड, नो?
कोर्ट इस तरह के ओल्ड डॉक्यूमेंट्स में कस्टडी को प्रूव करना पड़ेगा,
कस्टडी प्रूव करना पड़ेगा।
आई एग्री दैट विल बी
बताइए क्या बोलना है?
They are not shown what prevented them from filing or making these documents marked as
No.
exhibit in the trial.
You see, they deposed. They say that it was very much there in the records of the learned trial court. They might have filed it along with the documents. They deposed also that there was a further report, correct? This is what they are saying. They deposed also that, but incidentally it could not be marked. Therefore, they filed. It is not something that they are bringing on record for the first time before the first appellate.
But in that case, you have to see whether marking of these documents will affect the judgment or not.
It will affect the judgment. After all, they are claiming through hukumnama. Hukumnama coupled with jamindari debt receipt has a bearing in the matter.
What is the counter finding that first time you were recognized as a tenant in 1973? Before that,
So whatever it is, whatever they write, this hukumnama coupled with zamindari debt receipt has some value. But this will require oral evidence.
Yes.
Otherwise, it cannot be done. This oral evidence has to be done by the trial court.
First appellate court can also do that.
First appellate court can also.
usually evidences are taken by the trial.
We can leave it to the first appellate court to act in accordance with law. They may ask the trial court to.
That what is the 141, 123, 106. That can be done by the appellate.
Today only mentioned 3 dates.
Yes.
Suit was filed on 6/12/97.
Records have come.
From the decree.
Okay, 6/12/97.
Suit was decided on 6/6/2008. And thereafter, additional evidence has been filed on 4/6/16 and 14/6/16. After more than 20 years. And even when the suit was decided in the year 2008,
4/6/20, 4/6/16 and
14/6/16.
that's right. This has come up at a much later stage.
Yes.
But the document was there in the records of the trial. This is what this is.
This is the submission. This is the submission. Now waiting for respondent.
Is this submission correct or not correct?
Until the records come, which we not verified.
The reason, the reason which has been stated in the application which the learned counsel just read, supplementary affidavit page 7, the application. The reason is यह कि भूलवश निम्न न्यायालय में परदामीन रिपोर्ट को प्रदर्शंकित नहीं किया जा सकता.
Yes.
So the explanation is merely
You
that
see, there are
mistake.
two things. The litigant in the court while filing an affidavit would never say that it is the fault of the court. Right? They say that this document was very much on record, but by mistake whosoever, it is not a case that it has been subsequently. If it was already filed along with the list of documents and the evidence of the plaintiff or whosoever is the person is mentioning about these documents, had he not, and this fact has also been mentioned in the plaint, it is very much mentioned in the plaint. So therefore, document filed but not marked exhibit. So this is something which is not an afterthought. Maybe that a petition was filed later stage before the first appellate court. You know how the यहाँ पे तो 95 में भी अभी substitution भी file हो, additional evidence second appeal में भी file हो रहा है 95 का appeal में. वो नहीं बोल रहे हैं. The document already record पर है, then there should not be any reason to, there is no latches, you can say. There is no latches. Boolworth mark नहीं हो पाया. The document record पर है, there is no latches. It is still lying there. It is still there. Certified copy क्यों नहीं निकाली उसको?
सर्टिफाइड कॉपी मिलता नहीं है जो डॉक्यूमेंट
मार्क नहीं हुआ exhibit में।
उसकी एग्जिबिट जो होती नहीं उसकी सर्टिफाइड कॉपी कोर्ट में देते नहीं.
आपने कोई लिस्ट के साथ फाइल किया था, वो तो हम लोग रिकॉर्ड मंगाएंगे तो उस डॉक्यूमेंट को भी मंगाएंगे.
हाँ, लेकिन ये रूल है.
And if it is found that it is not there, then it is at your
No,
risk.
it is there. That is what is the file on affidavit.
Affidavit पे तो बहुत सारी चीजें. We'll admit it on that.
I
Call for
am-
the records and decide.
Brought that document, that application itself on. Both the application dated 44/6 and
देखिए, heard the learned counsel for the parties. Appearance is complete.
I am appearing for respondent 7 and 9.
I'm for 11.
Mr.
7, 8, 9, 10, 11 have appeared. Correct? ये बाकी तो सरकार है.
या बाकी सब.
भूदान यज्ञ कमेटी का क्या करें?
और एक आध दो ने हमें सपोर्ट किया.
सपोर्ट किया.
9 and 10 सपोर्ट.
ये 1 to 6 का क्या
1
करें?
to 6 तो सरकार
नहीं, भूदान यज्ञ कमेटी
वो भी एक उनके साथ ही रिलेटेड है इसका.
किनके साथ? सरकार के साथ. तो नोटिस तो जाएगा ना.
ये नोटिस भी जा सकता है कहीं तो.
इसको नहीं, सरकार अपियर नहीं करती है इनकी तरफ से.
Patna committee had refused to take notice.
It has come. झारखंड वाला?
Jharkhand was accepted.
Jharkhand has accepted. File refused. Same has been received by office clerk. Is accepted as valid. Notice upon 6 is also accepted as valid. 5, 6 हो गया, बाकी तो सरकार है, बाकी लोग अपील कर रहे हैं. Or the learned counsel for the applicant and the learned counsel appearing on behalf of 7 to 11. So far as respondent number 5 is concerned, they have refused to accept notice and the notice has been validly served upon respondent number 6 as per order dated 17th of September 2025. The learned counsel for the appellant has submitted that two documents were filed apart from others before the learned court. One was the further mean report and two zamindari rent receipts. Two zamindari rent receipts. Further mean report and two zamindari rent receipts. He submits that though in the plaint it was clearly averred that hukumnama was issued after the further mean report.
पहले मेजरमेंट कराए हैं मौका नहीं भी पाए पहले मेजरमेंट होना है उसके बाद ही
Though in the plaint it has been clearly mentioned that Jagatpal Vaidya approached the ex-landlord for settlement of land who got the same measured through Amil and granted parcha and then settled the land. And Jagatpal Singh validly Jagatpal Vaidya regularly paid rent to the ex-landlord and obtained zamindari rent receipt. He submits that this averment in the plaint was also supported by the evidence on record, but by mistake the document which was filed in the suit was not marked as exhibit. This accordingly, a petition under Order 41 June 27 CPC was filed before the learned first appellate court for marking of the same documents as exhibit. He submits that on the day the first appellate court's judgment was passed, on the very same day, though by a different order, the plea of additional evidence was rejected.
First morning session he passed the rejection order
That should
and
be
the
sufficient.
post
He
session.
submits that this aspect of the matter has been brought on record by filing a supplementary affidavit before this court. The learned counsel has submitted that the documents which were already placed on record before the learned trial court have serious bearing in the matter, as the plaintiff was claiming on the basis of Sada Hukumnama and the Amir report and the Zamindari rent receipt has a bearing with regard to the possession of the plaintiff. He submits that the document sought to be marked as exhibit was not by way of an afterthought. Rather, it was only by an error that the documents were not marked before the learned trial court. He has submitted that the substantial question of law number A calls for consideration by this court. And if this court if this court ultimately finds that the documents were required to be marked, were required to be taken into consideration by way of additional evidence by the learned first appellate court, then the matter has to be remanded to the first appellate court for the needful. The learned counsel appearing on behalf of the respondents have pointed out that the petition seeking additional evidence was filed only in the year 2016. He has also submitted that the records of the case are required to be called for to find out as to whether the plaintiffs had actually placed those documents on record. The learned counsel has also submitted that the state documents cannot be simply marked as exhibit. It has to be proved by oral evidence, and the defendant would have a right of liberty. This appeal is admitted for final hearing on the aforesaid substantial question of law number A as suggested by the Council of Appellant, Court Petition. The service of notice upon दोबारा सर्विस कर दो, दोबारा भेजना पड़ेगा नोटिस. स्टेट और कहाँ है? 5 and 6 तो who is for the state?
The state is a necessary party in this case, because they are living through Pasha, which has been granted by Islam.
उनको भी नोटिस हुआ था, स्टेट को भी नोटिस हुआ था.
If you listen to direct, I will serve copies on the.
Let the counsel for the state is appellant is directed to serve a copy of the two copies of the memorandum of appeal along with all its enclosures and other affidavits which have been placed on record in the office of learned advocate general to ensure representation of the state in this case. So far as notice upon respondent number, the respondent number 7 to 11 have already entered their appearance. No notice need be issued to them. Respondent number 5 has refused to accept notice, and respondent number 6 was duly served but nobody has entered appearance. Let the records be called for from the concerned court. The trial court is directed to send the original record to this court along with the documents, the original records before this court. And while sending the records should specifically mention as to whether the furtherming report and the two zamindari rate receipts were placed on record by the plaintiff before the concerned court.
It will be before the trial court.
Before the trial court, the records be called upon deposit of special messenger cost by the appellant within 10 days. Sorry.
The document, the copies of proposed exhibits may be given to us so that we can those documents are there in the state.
अब बता दीजिए जो भी आपके डॉक्यूमेंट्स था उसको कॉपी तो दे देंगे ना. कहाँ है वो डॉक्यूमेंट्स जो आप फॉरवर्डिंग रिपोर्ट कहाँ है? कोर्ट में भी डालिए ना.
रिपोर्ट में है
नहीं आ नहीं जाएगा. आपके पास तो है ना कॉपी. फाइल कर दीजिए.
But it has come in on the affidavit. कोर्ट ने भी ऐसा नहीं कहा है कि जो रिजेक्ट किए हैं.
अगर वहाँ से डॉक्यूमेंट नहीं आएगा तो आपकी कोई बात को नहीं मानेंगे.
नहीं, डॉक्यूमेंट है.
डॉक्यूमेंट है तो ठीक.
और हमारे पास
तो उनको तो डॉक्यूमेंट प्रोवाइड करेंगे ना.
अभी नहीं.
दे दीजिए. पंद्रह तारीख 15th 15 दिसंबर। आपका इतना क्या बता 31 में क्या किया?
एडमिट हो गया उसमें खाली ह्यूमन अपीयरेंस
उस कुछ नहीं
जूनियर रिप्रेजेंटेटिव ओनली फॉर
उनका अपीयरेंस रिकॉर्ड कर दीजिए। आउट ऑफ टर्न फॉलो आउट किए
दैट
अपीयरेंस में
Forest, Benson case item 13, second appeal 205 of 2023.
एडमिट हुआ है कि नहीं?
क्वेश्चन
फ्रेम भी हो गया, एडमिट भी है।
कहाँ है?
ये ऑर्डर डेटेड हो रहा है दिखाया 6/8/2024 था। ऑर्डर नंबर 5
और कौन-कौन है इसमें रिस्पोंडेंट? सब अपीयर हो गए?
Lordship, I am appearing on behalf of 1 to 5 and 7 and 8.
और इसके लिए परफॉर्म ये क्या होगा?
सब अपीयर हो गए?
सारे
हाँ तो आप बहस करिए ना, आप क्या एंट्री मॉडरेट से?
Lordship, इसमें कोई भी डेट या आज ही
आज ही शुरू करिए।
माय सीनियर सभी के साथ इसका एकदम
कोई बात नहीं, आप शुरू करिए।
बीसी से
बीसी से तो बीसी से सुनेंगे ना। बहस करिए। देखिए जब केस मैच्योर हो गया ना, एंट्री मॉडरेट का काम ही बना।
नहीं
केस मैच्योर हो गया।
वो है उस पर किसी को इन्फॉर्मेशन भी दिया है।
हाँ तो अभी तो ऑन नहीं ज्वाइन नहीं किया अभी तक। जहाँ पार्टी अपीयर हो गया, एंट्री मॉडरेट का काम ही बंद। फिर क्या? अब बहुत इजी सी क्वेश्चन ऑफ लॉ इसमें है ही क्या? बताइए।
दो ही क्वेश्चन हो रहा है।
हाँ दो ही है, लेकिन उसमें सेटल लॉ है, इसमें क्या सब्सटेंशियल क्वेश्चन ऑफ लॉ हम डिसाइड करेंगे? द लॉ इज सेटल्ड।
यस
हेलो।
हाँ बोलिए।
हाँ मैडम, ये इसमें इसलिए हमको मिला है पहले से ही और उसको वेकेट करने के लिए आईए फाइल किया है उन लोगों ने।
नहीं वैसा कुछ नहीं करना है। अब सब पार्टी अपीयर हो गई है, सब्सटेंशियल क्वेश्चन ऑफ लॉ बन चुका है, रिकॉर्ड आ चुका
हाँ
है।
बन चुका है।
अब बहस करिए। अब आगे
तो बहस फाइनल रख दिया जाए।
फाइनल जब बोलिए तब कर देंगे, कल से कर लीजिए।
हाँ क्योंकि अभी हम एक्चुअली हमको चोट लग गया है कमर में, इसलिए हम थोड़ा सा दर्द में है।
कब करना
दर्द में है। जनवरी में रख दिया जाए, बस कर देंगे फाइनल।
दिसंबर है, नवंबर भी आधा से ज्यादा बचा हुआ है, जनवरी क्यों?
ये लोग अपोज कर रहे हैं सर।
नहीं, कुछ दिन 10 दिन 5 दिन के बाद रख दिया जाए वो ठीक है, लेकिन एकदम
सर देखिए आपके जो जूनियर है ना,
गिर गए हैं, चोट लग गए हैं।
नहीं हम आपको पूरा एक इंतजाम कर देते हैं, आपको ज्यादा मेहनत नहीं करना पड़े ऐसा। आपके जो जूनियर है ना, ये काफी मैच्योर जूनियर हैं, थोड़ा नोट बोर्ड बनाने इनको बोल देते हैं, ठीक है? और आप लोग आराम से घर पे बैठ के नोट्स बना लीजिए, उसके बाद 10 दिन बाद रख देते हैं, फिर हम लोग सुन लेंगे। आप लोग भी नोट बना लीजिए, ठीक है? उनको कोई पर्सनल डिफिकल्टी है 10 दिन में अपने घर पे बैठ के आप जाके उनके यहाँ थोड़ा बनवा लीजिए, ठीक है? उससे हो जाएगा ना, थोड़ा रिटिन नोट होगा तो हो जाएगा, फिर तो कोई दिक्कत ही नहीं है।
ठीक है ठीक है।
ज्यादा जरूरत नहीं है, बहुत सिंपल है।
कोई बात नहीं, ज्यादा जरूरत तो हमको तो टाइम लगेगा ना
जी
समझने
जी,
में।
लेकिन बहुत
अब सीनियर बहस करेंगे तो कुछ क्या क्या बहस करेंगे, अब क्या ही पता।
है, बहुत लिमिटेड।
कब करेंगे?
2 वीक्स के बाद।
कोई ऐसा डेट बताइए जिस दिन कोई और केस हम नहीं फिक्स किए और उस दिन दूसरा केस मत फिक्स करिए, हम दूसरा केस नहीं फिक्स कर रहे हैं उस दिन।
हम रेडी हैं।
बताइए सर मुझे कोई ऐसा डेट बताइए।
24, 25 को नीस का मैरिज है और सिर्फ हम वो 2 दिन
नवंबर ना,
इसी बात जी नवंबर
1 दिसंबर तक एकदम सही दिन है, कुछ रखें
मंडे
1 दिसंबर मंडे तो एकदम शुभ दिन।
ट्यूसडे एक दिन बाद
क्यों?
फाइनल डिस्पोजल में एक लड़से दिन भर तो लगना ही है, लड़से क्योंकि सीनियर करेंगे
इतना दिन भर नहीं लगेगा, ये लोग तो पहले ही फाइल कर लेंगे रिटन सबमिशंस
ठीक है आपसे तो जैसा लग सकता
10:30 बजे से। ठीक है?
सेकंड
तो शुभ घड़ी निकालें।
घड़ी नहीं निकाला लड़से 30 को भी मैरिज है एक चाईबासा में
आप तो पूरा शादी में ही जाइए, फिर वकालत क्यों कर?
नहीं लड़से 2 है लगातार तो इसलिए एक के बजाय चूंकि एक को ही बारात विदा होगा 2 को रख दिया
हमको भी तो संडे को पढ़ने में सुविधा होगी ना।
पढ़ लीजिए लड़से एक के बाद 2 को मंडे के बाद ट्यूसडे ही सेट कर रहे हैं, कोई और ज्यादा कमेंट्स एक दिन का बस
Learned counsel for the parties are present. A petition for stay vacating has been filed.
और लड़से को आइए फाइनल में बहुत रीजन मुझे कुछ है नहीं ऐसे क्योंकि हमसे पहले वाले हैं
दूसरे एडवोकेट को दोष देना बंद करिए, फाइल
नहीं,
नहीं है तो सारा
दोस्त
दिन
फाइल है लड़से पर रीजन कुछ
आइए नंबर बताइए ना।
आइए नंबर है लड़से 5633
आइए नंबर 5633 of
of 2025
2025 has been filed for vacating the stay passed by this court. The learned counsel for the appellant has submitted that the case is otherwise ready for final hearing and short substantial questions of law have been framed. He submits that he is ready for final disposal of the matter and a date of hearing will be fixed. Mr. Sarju Prasad has joined the proceedings online and has submitted that on account of certain medical condition, he is not in a position to argue the case today. With the consent of the learned counsel for the parties, the matter is directed to be posted for final disposal on 2nd of December 25 to be taken up as first case at 10:30.
Till that date, stay में kindly be ordered to
इसका
be.
जरूरत नहीं
इनकी मॉडल होगी तो सारा प्रिंट कर दिया
है। Since the matter is being fixed for final disposal, this court is not inclined to vacate the entry for the present. In case नहीं take up होता, फिर से fresh file करेंगे,
ठीक है
take up हो जाएगा। आइए close करते हैं, आइए close करते हैं। Counsel for the parties have undertaken to file short synopsis of arguments with supporting judgments which they seek to rely upon. Latest trial 28 तक फाइल कर दी जाता है। 28 से लेट मत करिएगा, उसको पहले कर दीजिए और सॉफ्ट कॉपी भी देंगे मेल से, हार्ड कॉपी भी चाहिए और सॉफ्ट कॉपी। हाँ फाइनल डिस्पोजल on 2nd December as per stated.
अब
2 दिसंबर को फाइनल डिस्पोजल के लिए
From supplementary list orders item 4, second appeal 59 of 2014.
Who is for the appellant? Yes. क्या हुआ सेटलमेंट? सेकेंड अपील है ना? सब्सटैंशियल क्वेश्चन ऑफ लॉ बना हुआ है कि नहीं बना हुआ है? 2014 का अभी तक सब्सटैंशियल क्वेश्चन ऑफ लॉ नहीं बना है। आज वो है नहीं तो आज डिसमिस कर देते हैं उनका केस, फिर क्या जरूरत है? कॉम्प्रोमाइज की बात हो रही थी, आज एब्सेंट है, जॉइंट कॉम्प्रोमाइज फाइल भी नहीं किए हैं। कोई बात नहीं, डिस्कस कर देते हैं। इसमें कोई आईए पेंडिंग नहीं है ना? ये क्या है? मॉडल्स ऐसे नंबर 59 और 2014 on 26/9/25, when the case was taken up, it was submitted by the learned counsel for the parties that the parties are likely to enter into settlement out of court, and they wait for some time to file joint compromise petition. The case is of the year 2014, and no substantial question of law has been framed so far. आप किसकी तरफ से? Appellant is absent, and counsel for all the respondents is present. सब respondents की तरफ से कुछ compromise की बात हुई?
अच्छा नहीं थी तो उसके बाद ही अपना कुछ इंस्ट्रक्शंस दिए नहीं
The counsel for the respondents is clueless about joint compromise. Nobody has appeared when the case is called out. No advance notice seeking adjournment has been circulated. Accordingly, this appeal is hereby dismissed. For non-prosecution.
Item 5, second appeal 531 of 2017.
There is one early substitution of the legal years of the applicant. This is notes. Early number 13762.
Substitution of appellant.
Yes.
IE number?
13762.
When did he expire?
Expired on these are these filed on 6/10/20.
file wakalatnama on behalf of the proposed legal heirs?
One of these reverse.
Why not others?
Others will come.
Others have not come. They are not interested.
One is out of
एक ही फैमिली के 3 लोग बोलेंगे others have not come.
lots. The
सब एक ही साथ रहते हैं. They are all living together.
wife is suffering from several elements.
So वकालतनामा फाइल करने में क्या है 1 मिनट का काम?
वो साइन
नोटिस नहीं करेंगे आप, तो वकालतनामा लेके आइए। कौन साइन नहीं करेगा? मैं नोटिस करके 6 महीना आपको नहीं एक्सटेंड करना है आपका केस।
wife
तीन का नाम दिया हुआ है, सब एक साथ रहते हैं, फिर आपको वकालतनामा फाइल करने में क्या परेशानी है बताइए?
wife sound mind की नहीं इसको जैसे नहीं सही कर
साउंड माइंड की नहीं है तब तो वो वकालतनामा फाइल ही नहीं कर सकती है अंडर एनी सर्कमस्टेंसेस।
साइन नहीं करना चाहती
साउंड माइंड साइन नहीं करना चाहती है तो साउंड माइंड की है, नहीं तो कर देती है। साउंड माइंड के लोग दिमाग लगा के काम करते हैं। साइन नहीं करना चाहती है तो पागल है, ऐसा होता है क्या? बताइए क्या करना है?
May I pray one thing? They can be impleted. The persons who have signed, they can be impleted as applicant, and the rest who is not signing, they can be impleted as pro forma respondent. Interest of the applicant substituted and the pro forma respondent would be the same.
लेकिन आखिर नोटिस तो जाएगा ना?
Notice to pro forma because it is the interest, common interest they are putting. Now, this is the case in which I was opposing. Why I was opposing otherwise, that your Lordship may kindly see the cost item. There are 86 parties respondents, and the suit was filed in prior to 2000. It was of 1997. Ultimately, the second appeal has been filed in 2017, and it is still at the stage of admission or condonation of. Now, therefore, Your Lordship, there was an order of issuance of notice because the appeal was filed belatedly. Therefore, mechanically, that obviously issuance of notice.
वो तो हम तो करते ही थे ना,
but
थोड़ा सा लेट कर देते 5 दिन।
नहीं, अब problem क्या है? There is another order of this honorable court itself, where the honorable judge has taken note of the fact that how this delay is being unnecessarily. There is an order in this record itself.
and thereafter the coordinate bench has passed the order, the issuance of notice is necessary for the parties.
This is not only one case. I say that if Your Lordship, even if
कितने
there
बच
is,
रहे हैं, कितनों की सर्विस बच रही है?
Almost all the services have been completed, some of the respondents.
सब मतलब who some?
And
Who are those some?
lots. Respondent number 21 to 24 and 28, 29, 30 to 34 have not appeared, and for their appearance will be substituted service paper publication was made, and to this effect the supplementary affidavit has been filed.
So the service is complete now.
Yes. But during pendency now of this appellant died, and therefore the substitution is
if it is because it is within time, Your Lordship, it can be allowed. The main matter can be proceeded.
Substituted service किसका हुआ है?
21 to 24, 28, 29, 30 to 34.
और ये 70 was not found. $70 was not found.
But in audio note that was removed, and that is why the paper publication was removed. Although I have submitted to.
तो 70 का तो not found है ना? एक और पेपर पब्लिकेशन आप करते रहिए पेपर पब्लिकेशन। 70 का क्या होगा? हम उसका नोटिस कैसे एक्सेप्ट करेंगे?
Without the substituted service के लिए मेरा period था, but there was some error in the order made that was not accepted by the registry.
Error in the order तो आपको rectify कराना था ना. If there is an error in the order, you should have filed an application for rectification. आपको 70 का अलग से सब्सिट्यूट आपको क्या करिएगा 70 का? 70 को कैसे सर्व करिएगा?
I have already filed, but the registry not accepted only
So
because there was some typographical error in the order and therefore
आपके कहने से आपको ऑर्डर यहाँ पे मॉडिफाई करवाना था ना कि 70 नंबर छूट गया. तो फिर से कराइए पब्लिकेशन. सेम ऑर्डर कर देते हैं पब्लिकेशन का. कराइए. कोई डिफिकल्टी कुछ नहीं है. आपको पब्लिकेशन कराने में इतना मन लग रहा है कराइए.
through police station
नहीं नॉट फाउंड है तो कहाँ से छूट गई? उसके लिए सब्स्टिट्यूटेड सर्विस के लिए आपको फाइल करना पड़ेगा. 2017 का ये सेकेंड अपील है ना, ये 2028 तक पहुंच जाएगा आराम से.
so one chance
2037 पे पहुंच सकता है.
through police station including
जब 70 मिले ही नहीं तो हम लोग क्या करें? आपको खाली पेंडेंसी से मतलब है, ऐसा लग रहा है.
most of the pension numbers
2017 से क्यों इतना पेंडिंग है? बताइए.
3 times notices have been filed.
आप अपना सब्स्टिट्यूटेड सर्विस ऑफ नोटिस फाइल करिए, या आपको ड्रॉ करना है करिए. तो पेंट्री ऑर्डर कर देते हैं, या तो पिटीशन फॉर सब्स्टिट्यूटेड सर्विस ऑफ नोटिस करिए, या फिर आप एक्ट इज प्रेजेंट.
So PS1 notice may be sent.
Notice has been received by saying that not found. That's it. Seventy में addressee had left.
Additionally, Your Lordship, I was appearing for 64.
You were directed to take fresh steps for service of notice upon respondent number 70 also.
That has
At
already
his present and correct address.
that has already been taken and thereafter my paper publication was made.
पेपर पब्लिकेशन कौन सा है ये फाइल के? ऐसे नंबर 531 ऑफ 2017. ये जब एक आदमी का वकालतनामा फाइल कर रहे हैं ना, कुछ अच्छा बात नहीं बता रहा आपके बारे में. अपीलेंट उसका एक ही टेंडेंसी है कि कैसे इसमें टाइम होता है. टाइम कर देते हैं 2037 में डिसाइड हो जाएगा केस 2037. आपको वकालतनामा आप अपने घर वालों को नहीं ला सकते. माँ को पागल डिक्लेयर करती है. किस तरह का स्टेटमेंट है ये? She is not of sound mind because she is not signing the वकालतनामा. सही है.
And now so far the concern of necessary for the in tribal the custody of village and the women are not having the great experience.
एफिडेविट फाइल कर दीजिए, रिजेक्ट कर दीजिए. आज ये फाइल कर दीजिए कि उनको नोटिस करने का जरूरत नहीं है. शी इज नॉट नेसेसरी पार्टी. शी विल नॉट बिकम पार्टी एट योर रिस्क. एंड देन वी विल डिसाइड उनका कोई राइट था कि नहीं था. शी इज अ विडो. विडो को तो कोई राइट नहीं है कस्टमरी लॉ में.
Only maintenance.
तो उनका राइट है ना. फिर ऐसे बोल दिया उनका कोई राइट नहीं है. ट्राइबल कस्टमरी लॉ में शेयर नो राइट्स.
hereditary right.
जीवन भर रहने का राइट है ना, काफी है. आई नंबर 13762 of 25. This petition has been filed for substitution of the plaintiff sole plaintiff who is said to have expired on 30/8/25. The names of legal heirs and successors has been mentioned in paragraph 5(4) of the interlocutory application. However, wakalatnama of only one of the legal heirs has been filed, who is proposed legal heir number, who is proposed to be, who is shown as 1B in the interlocutory application, namely Asaf Munda. Counsel for the respondents has no objection to the prayer for substitution. Considering the aforesaid submissions, the prayer for substitution of the appellant is hereby allowed to IA number 13762 of 25. Of the appellant is allowed. The counsel for the appellant is directed to delete the name of the appellant from the first title and insert the name of one within bracket B, namely Asaf Munda, in the memo of appeal as appellant, and other two, namely Isrin Munda and Premdyan Munda, be shown as pro forma respondents.
Or if he says that she's of unsound mind, then provisions of order 32 for
ऐसे होता है
नहीं
हम
ठीक
सब
है
में। किसी को भी आप पागल
इनको
declare
एक
करें।
एप्लीकेशन देके वो गार्जियन अपॉइंट हो जाता उनका
अनसाउंड माइंड के लिए उनको ना मतलब
नहीं होगा तो प्रोफॉर्मा बिकॉज
ये सब बात हम सुनने नहीं वाले।
नहीं इंटरेस्ट ऑफ ऑल द appellant and the प्रोफॉर्मा respondent would be defended by the appellant themselves.
Let notice be issued to Isran Munda and Premdyan Munda through the concerned police station, for which requisites be filed within 1 week from today. The record shows that respondent number 70, IA disposed of. Record shows that respondent number 70 was not found. Counsel for the appellant, क्या करना है आपको? प्रेजेंट एंड करेक्ट एड्रेस पे भेजेंगे कि फिर कहाँ भेजेंगे? सेम एड्रेस पर भेज रहे हैं प्रेजेंट एंड करेक्ट में, सेम एड्रेस पे ही बार-बार भेज रहे हैं आप।
सबका सब्स्टिट्यूटेड सर्विस इज all substituted.
Counsel for the appellant has submitted that notice was sent to present and at the present and correct address of respondent number 70, but again it has been received by stating that he was not found. Substituted service का फाइल कर दीजिए, फाइल द पिटीशन for substituted service. He prays that he shall take one more attempt to issue notice upon respondent number 70 at his present and correct address. Okay? Let the notice be issued upon respondent number 70 at his present and correct address within a period of 2 weeks from today, or an appropriate petition be filed seeking substituted service of notice within the same time frame. नहीं करिएगा तो किसमें से? Alternative आपको दे दिए। कुछ नहीं कर सकते। We can't do anything. बताइए कब तक? Speed post से, है ना? Present and correct address to speed post. Office to track speed post delivery. Post on 15 December. आइए एक ही डिस्कशन, बाकी तो कोई आइए नहीं होगा। एक और कौन सा
दो
आइए?
सब
लिमिटेशन
दूसरा किसका सब्स्टिट्यूशन?
सब्स्टिट्यूशन नहीं है, लिमिटेशन है।
कितना दिन का डिले है?
53
प्रॉब्लम इज पूरा गांव को बनाती है पार्टी, तो अब आई एम ट्राइंग टू अपीयर फॉर मोस्ट ऑफ देम, बट कितना
ये जो आपका नोटिस गया है सेकेंड अपील में गया है कि सिर्फ लिमिटेशन में गया है?
लिमिटेशन
और जब लिमिटेशन का नोटिस सर्व हो जाएगा तो मेन अपील में फिर से नोटिस होगा, उसके लिए फिर से सब्स्टिट्यूटेड सर्विस करेंगे। तो 2057 तक का प्रोग्राम है आपका।
जो लॉ है उसको हमको कंप्लाई
नहीं आई
करते रहिए आप, लॉ अपना कंप्लाई करते रहिए और जो जस्टिस है उसको डस्टबिन में डालिए। 2014 का केस लेके बैठे हैं, 2017 किसका सब्स्टिट्यूशन पेंडिंग है?
आइए 1110
डिसमिस अब नॉट प्रेस कर देते हैं। Respondent 21, ये इंफॉर्मेशन है टू द कोर्ट, आपको सर्व करके फाइल किया गया है।
सब्स्टिट्यूशन उसको फाइल कर दिया और वो एपीए कर गए थे।
ये अलाउ हो चुका है सब्स्टिट्यूशन। रेस्पोंडेंट नंबर 31 का सब्स्टिट्यूशन अलाउ हो चुका है, बताइए।
हो चुका है
21 हो चुका है।
1948 आइए 1948 और 20
1948 में बहुतों का सब्स्टिट्यूशन है। 1948 का क्या करना है?
लॉ कर दिए
नोटिस सर्व हो गया सबको?
नोटिस सर ये है ऑलरेडी एपीए
सिर्फ 21 का नहीं है सब्स्टिट्यूशन, आपको पता ही नहीं है। रेस्पोंडेंट नंबर 16 भी है उसमें, 76 भी है, 80 भी है। 76 का तो पता ही नहीं है। इस तरह का ऑफिस बनाते हैं, इनको नोटिस नहीं हुआ था सबको। 16 has been served, 76 received by brother, 76-1. आप ऑफिस नोट नहीं देखते हैं?
आज मैं नहीं देख पाया
बहुत अच्छा।
नोट्स रियल
हम बैठ के यहाँ पे ऑफिस नोट देखा और आपका पिटीशन अलाउ कर
without my consent yesterday case was mentioned for today my lord today I have attended the ceremony my lords of the one of our colleague had my lords that's what that's fine
उसमें भी लग रहा है एक आध का पब्लिकेशन होगा, पेपर पब्लिकेशन देख लीजिए क्या करना है।
उसको एग्जामिन कर लेंगे।
आप बहुत खुशी की बात है एग्जामिन करने कब का डेट दिया? उसमें ऐसे ऑर्डर नहीं हो सकता। बहुत सारे लोगों का सब्स्टिट्यूशन है, एक पिटीशन में आप लोग मल्टीपल लोगों का सब्स्टिट्यूशन क्यों फाइल करते हैं? दिस शुड नॉट बी डन। क्या यही सिस्टम है क्या? एक पिटीशन में अपीलेंट का भी 4 अपीलेंट का, 4 डिफेंडेंट का,
ये केवल रेस्पोंडेंट का
फिर भी एक पिटीशन में इतने लोगों का सब्स्टिट्यूशन फाइल करेंगे, वो पिटीशन का भी डिस्पोजल ही नहीं होगा, चलते रहेगा। और सबका लिमिटेशन अलग अलग है ना, कोई कब मरा, ये बैठ के हम लोग कैलकुलेट करते रहेंगे। यू शुड नॉट, आई विल नॉट परमिट दिस काइंड ऑफ अ पिटीशन। इन वन पिटीशन यू शुड फाइल सब्स्टिट्यूशन ऑफ ओनली वन पर्सन, क्योंकि उसका लिमिटेशन, हर एक का लिमिटेशन अलग से काउंट होगा ना, कि नहीं होगा? तो फिर अब पूरा पिटीशन में सबका अलग अलग लिमिटेशन कैसे होगा?
जब इंफॉर्मेशन मिला उसके उस समय से हम विदिन टाइम एक ही साथ है, इसलिए हम
नहीं, कुछ ऐसा नहीं है। This should not be, Mr. Rahul. I'm telling you to the entire bar. इस तरह से मल्टीपल लोगों का एक पिटीशन में, आज एक केस में 88 में मरे हैं, एक 98 में मरे हैं, एक 2008 में मरे हैं, कॉमन पिटीशन फॉर सब्स्टिट्यूशन। और कॉन्डोनेशन ऑफ डिले का कोई प्रॉपर एक्सप्लेनेशन हो ही नहीं सकता है। डिले कॉन्डोनेशन में एक ही डेट लिखिएगा ना कि इतना दिन का डिले है, कैसे होगा? This is creating lot of problem.
But one thing can be allowed, that in a single petition, substitution as well as condonation of
That is
delay-
allowed. There is no problem. अलग से उसका डिले हम लोग कहाँ इंसिस्ट करते हैं, लेकिन जब आप मल्टीपल लोगों का डिफरेंट डेट
हाँ,
ऑफ
वो-
डेथ को
वो
लेकर
that-
आप करते हैं तो कितना कॉम्प्लिकेशन है।
because delay would be absolutely
डिले विल बी डिफरेंट फॉर डिफरेंट पर्संस। कोई आपका फैमिली मेंबर होगा, कोई आपका पड़ोसी होगा, कोई अमेरिका में रहता होगा, सबका डिले कॉन्डोनेशन एक जैसा होगा क्या? हमको बहुत मन है कि हम जो है ना अबेटमेंट में बहुत सारे केसेस खत्म कर दें, हमको लग रहा है करना पड़ेगा। आई हैव बीन वेरी वेरी लिबरल इन कंडोनिंग डिले, अब ये होगा नहीं और हम डिले पर ही कर देंगे। सब्स्टिट्यूशन में डिले आएगा विदाउट प्रॉपर एक्सप्लेनेशन, पड़ोस में आपके रहता है, मर गए, बोलते 10 साल से पता ही नहीं होती मर गए, सही नहीं है ना? हम सोचते हैं डिले में क्यों कंडोन, मतलब अननेसेसरी केस को डिसमिस करें, लेकिन कंडक्ट ऐसा है कि लगता है कि एकदम ही नेग्लिजेंट, एब्सोल्युटली नेग्लिजेंट। अब आप लोग जो है ना सब्स्टिट्यूशन पे बहुत तैयार होके आइएगा, 2-4 तो हम तो ऐसे ही, जहां हमको नहीं समझ आएगा ना डिले कंडोनेशन, आई विल डिसमिस इट एंड आई विल जस्ट प्रोसीड विद द मैटर। हम 10-10 साल का डिले कंडोन किए, बहुत ही ज्यादा लिबरल एटीट्यूड लेकर, लेकिन लग रहा है कि यहाँ पर हैबिट है 10 साल बाद सब्स्टिट्यूशन फाइल करने। सिविल लिटिगेशन का जो आप लोग यहाँ हाल बना के रखे हैं ना सब लोग मिलके, ये मत बताइए कि हाई कोर्ट में केस लिस्ट नहीं होता है। सब्स्टिट्यूशन फाइल करने के लिए केस लिस्ट होने का जरूरत नहीं है। जरूरत है क्या? केस लिस्ट होगा तभी सब्स्टिट्यूशन फाइल करेंगे? ये किस तरह का एक्सप्लेनेशन है? ये दिस आई एम फाइंडिंग इन मेनी ऑफ द पिटीशन फॉर सब्स्टिट्यूशन कि केस लिस्ट नहीं होता इसीलिए नहीं फाइल की। इसका क्या मतलब?
but not in my case.
Not in your case, certainly not your. It is a general observation. I'm bringing it to the notice of the councils. कि आप सब्स्टिट्यूशन डिले कंडोनेशन पे तैयार हो। अब हम मैकेनिकली डिले कंडोन नहीं करें जो हम कर दे रहे थे अभी तक। थोड़ा ही देखने से लगता था चलो कर देते हैं, ट्राइबल लोग हैं नहीं जानते हैं, लेकिन अब हमको ऐसा नहीं लगता।
I'm not defending those petitions which are not properly explained, but this particular thing was that case list नहीं होता है, इसी के लिए ये reason था कि because in trial court, because regular dates are fixed, the client is in touch with the advocate. Therefore, whenever a death occurs, there is a communication between the advocate and the. So this was the reason the
आपको लगता है
honorable.
कि मैंने प्रैक्टिस नहीं किया?
नहीं,
ठीक है ना?
ये
ये आप हमको मत सुनाइए कि केस लिस्ट नहीं हो रहा है तो लिटिगेंट जो है सो गया, और सोने का राइट तो लॉ नहीं बता।
बीच में तो अपील्स नहीं हुआ दिस ईयर बच्चे हम पहले का अप्रोक्सीमेटली 2008 एंड till 14-15 नहीं हुआ है। But I am not justifying all those for everyone. I say that there may be some reason for it.
बहुत ज़्यादा बुरा हाल है सिविल लिटिगेशन का, इसीलिए 4 बजे रखते हैं यार ऑर्डर्स की, कुछ तो शुरू के हो जाए, नहीं तो पूरा दिन ही निकल जाएगा सब्स्टिट्यूशन करने में। And those who have slept over their right, let them sleep over it. And I will dismiss their case. आज तो हम ऐसा मन बनाए हैं, कल से आप देखिएगा आपका सब्स्टिट्यूशन कितना स्ट्रिक्टली अलाउ नहीं करेंगे हम टाइम। एक और सबसे बड़ी बात है, एक सब्स्टिट्यूशन फाइल होता है, उसको अलाउ करते हैं, जैसे ही उसको अलाउ करते हैं दूसरा सब्स्टिट्यूशन फाइल होता है, उसमें लिखा रहता है कि इसके भी पहले वो मर गए। यही तो कहानी है। आखिर जो आदमी वहाँ रह रहा है वो तो 50 साल से रह रहा है ना वहाँ पर, उसको क्यों हम डिस्प्लेस करें? Why should we? जो आदमी 50 साल से एक जमीन पे रह गया तो उसको क्यों हम डिस्प्लेस करेंगे? नहीं करेंगे। चलिए।